Good day, everyone. Thanks for joining us. Yes, it is Sunday, and that means that it is time for the Crime Talk weekly recap of all the top stories located in one convenient video for you. Hope you enjoy it. Have a wonderful weekend, and we'll see you Monday on Crime Talk.
All right, lawyer.
The man arrested in the horrific caught-on-camera attack in which a woman was lassoed with a belt from behind, dragged unconscious, and then sexually assaulted with some eerie precision. That's what the police are saying. Now, they're speaking off the record, but the police are saying this was just too clean. Nobody does it this systematically the first time. First time, they would make a mistake, and this guy didn't make any. This guy, Keyshawn Parks, was charged with first-degree rape, assault, strangulation, sex abuse, public lewdness, and harassment. Now, he had his head low and was wearing a white Tyvek suit when he was walked by two detectives from the Special Victims Division unit to a car and taken to the Bronx Criminal Court. Needless to say, he didn't answer any questions from the reporters as he was walking out. Now, this guy has two prior public arrests, just like I figured he would, but a little surprising. One goes back to October of 2018, where he was charged with third-degree assault and criminal mischief in the Bronx for allegedly hitting a 46-year-old woman during an argument and jumping on top of her. He punched her once in the head, causing a lump. According to the arrest records, he also allegedly threw her phone at a lamp, breaking the light. Now, back in 2013, he was also charged with theft of services for allegedly entering the rear of an MTA bus without paying, and police were unable to say if he has any sealed arrests. I figured he would have some arrests, probably a little more severe. Now, they are saying that public arrests. So maybe he's got a juvenile history, but this guy is 49 years old. What is he doing out lassoing women? I don't know. But this is where things get a little weird, is the victim was brought to the hospital and she's in stable condition. However, at some point, she allegedly stopped cooperating with the police. In New York City, as of May 5th, a total of 511 rapes have been reported throughout the city. That is the same total as they had during the same time in the previous year. 511 reported, ladies and gentlemen. Think about the numbers that haven't been reported. Bryan Kohberger and Bryan Kohberger's attorneys are saying, give us the evidence. That's right. The team is requesting new evidence in the ongoing Idaho quadruple murder case, and the judge overseeing the case is expected to hold two closed-door hearings this week to discuss recent requests made by Ann Taylor, the lead public defender for Bryan Kohberger. And the hearings, which will be held today and then on Thursday, will have a significant impact on the case and how it will probably unfold from here on out. Now, Kohberger's attorneys are requesting new evidence related to the probable cause affidavit used in Kohberger's arrest, including cell phone tower data, a video of a vehicle seen near the 1122 King Road where the murders were committed, and the information regarding a test drive. So Ann Taylor has stated in her motions, the state knows full well what they have and what they're withholding from us. We don't know what they're not going to show, but we know they exist. Now, Taylor said that at a hearing as well as in pleadings. Now, of course, the Latah County prosecutor, Bill Thompson, who's obviously leading the case against Kohberger, has rejected Taylor's claims that the state was concealing evidence. The characterization that we're just consciously withholding information to frustrate the defense team is utter nonsense, Thompson has stated. And he says that, listen, this is not true. We will provide everything that we can that is provided to us under the rules. Now, the defense is set to have two expert witnesses lined up for today's hearing. And that hearing is closed at the prosecution's request so that they can discuss specifics of certain evidence, some of which may not necessarily be presented at trial. Thursday's closed hearing will focus on the defense's request to review protected content regarding the investigative genetic genealogy records. The records were used by the FBI to identify Kohberger as a suspect, and the technique utilized DNA from a crime scene using public genealogy websites, which can help investigators determine potential suspects. And there is simply no legitimate reason that the way the IGG procedure in the case took place should be shielded from the public, the defense is arguing. This court has provided no authority for sealing those materials. So the defense clearly wants this information out in the public. So at that hearing on Thursday, the defense will call at least 2 witnesses, and they have several exhibits for that particular hearing. Now, last month, as you may recall, Kohberger's defense team filed a motion providing new information on an alibi where the defense planned to call Cy Ray, a former police officer who specializes in analyzing cell phone data in criminal cases, to serve as a defense witness and expert, and to dispute some aspects of the cell phone pings, including those pings that were identified in the probable cause affidavit. Now, the alibi motion said that Ray will testify that Brian Kohberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho, on November 13th of 2022. That Mr. Kohberger's mobile device did not travel east on the Moscow-Pullman highway in the early morning hours of November 13th, and thus could not be the vehicle captured on the Moscow-Pullman highway near Floyd's cannabis shop. The affidavit also alleges that Kohberger's cell phone pinged near his off-campus Washington State University apartment at 630 Northeast Valley Road at 2:42 a.m. on the night of the murders, and was later seen on the surveillance footage from the Washington State University traveling north on Southeast Nevada Street at Northeast Stadium Way. Now, as you know, the trial date has not been set yet again. Hopefully after these hearings, we'll see how much time will be needed, assuming the court grants the defense request, stating that, yes, we believe this information is out there. The prosecution just needs to get it. It's in their care, custody, and control, and therefore we need time to obviously review it, analyze it. How does this engage? How are we going to use it to engage in motions practice? And how does it affect the overall strategy of the case? So hopefully that will be done. Once again, huge disappointment that the hearings will not be televised. I have said this repeatedly. These proceedings should be televised. I am a firm believer that all proceedings in the judicial system should be televised. It is a public courtroom. The public has a right to know what is taking place. There are other hearings that are going on, trials that are taking place, where they should be televised. It lets the public know exactly what's taking place, and they can see with their own lion eyes whether what is being told to them is the truth or not, and they can decipher and say that is not admissible or it shouldn't be considered. It'll never come in at trial. It happens every day in courtrooms all across the country. Judges decide what evidence is coming in and what evidence is not coming in. And anybody can walk into that courtroom and sit there and observe. And to think that this case is somehow so special, routine procedures need not be followed, makes no sense to me whatsoever. Next on the docket, the Ella Riley Adler matter. Police in Florida confirmed Tuesday that they are in possession of the speedboat that hit and killed teen ballerina Ella Adler. She was 15 at the time, and she was out water skiing last weekend with friends. Now, the boat was discovered outside of a $4 million home in Coral Gables, Florida, in a private gated community. The Florida Fish and Wildlife Conservation Commission said that the owner of the boat is cooperating with the investigation, and it's not clear if the owner was driving the boat at the time that Miss Adler was hit. Now, Miss Adler, who was laid to rest in a funeral on Monday, was celebrated as a star and a force of nature after she died being struck by the boat in the Biscayne Bay there in Miami. The police describe it as a hit and run. Now, this case may be getting a lot of publicity because of Ella's grandfather, Michael Adler, who is the current U.S. ambassador to Belgium and was previously considered as a contender to be the ambassador to Israel when Joe Biden took office. There is an award of $20,000 that will be given if somebody can provide information to the person driving the boat. Now, Ella was being celebrated because she had appeared at such a young age in over 100 different productions of The Nutcracker with the Miami City Ballet, and recently appeared in a school production of Chicago.
Because it was the last
witness in the case against Chad Daybell by the prosecution. The climax was building. We were going to see if the defense case was going to begin. And what happened was a bunch of legal gymnastics to cover up the prosecutorial malpractice that took place. And let me explain. Like I said, prosecution calls their last witness, a special agent with the FBI. They huddle, make sure they have everything correct. The prosecution then rests. The defense makes their motion for judgment of acquittal, and it was kind of a perfunctory motion for judgment of acquittal, although Mr. Pryor says, hey, there are errors in the elemental issues. The judge says, okay, fine. Oh, but wait a second, Mr. and Miss Prosecutor over there. Have an issue. You filed your original indictment back in May 25th of 2021, and you said in count 4 that the death of J.J. Vallow took place on September 22nd or September 23rd of 2019. However, when you filed a motion to amend the indictment on February 20th of 2024 that it was granted, you state in that amended indictment, the one that we read to the jury, that Chad Daybell was responsible for the death of J.J. Vallow on September 8th and 9th of 2019. How do we fix this problem? Because Rule 7A says you can amend the indictment up until the moment that you've rested. Oh, and you have rested. So the judge, not sure what to do, but sees that there's an issue, takes 2 hours for the prosecution to come back. They make 3 arguments. First, they say, Judge, this is not a big deal. This is just a clerical error. Don't worry about it. And we filed a motion to amend the original indictment, but we only filed to amend counts 1, 2, 3, and 5, and not count 4, which is an issue here. So even though we filed an amended indictment that we presented to a grand jury, and the grand juror signed it saying that count 4 now has the date of September 8th and 9th of 2019, disregard all that, Judge, because you didn't grant that. So the original count 4 should still exist, even though the amended document says otherwise. And the prosecution says, hey, don't worry about it. The defense isn't prejudiced because they knew these dates were there. So don't worry about it. If not, let us do a variance, Judge, because we have this big date and we'll let the jury decide. Dates don't matter. Precise time and location don't matter. I call BS on that. Yes, time and date does matter. Otherwise, why would they be in every charging document, in every filing across this great land? All right. And then the final one was, hey, Judge, just let us reopen the case. So what does Judge Boyce do in this particular case? The man who's conducted most of this trial in chambers, giving the prosecution everything they want. And let me be clear, I have no love or like for Chad Daybell or Mr. Pryor, but what I do like is the rules being followed, okay? And the rules need to be applied equally to everyone. If an amended indictment that's filed doesn't mean that it's an amended indictment, then by God, somebody at the prosecution's office that's had 4 years to work on this case should probably figure it out and read something right. That's just the way it is. But they didn't do that, all right? So the judge says, well, I got to look at prejudice and I got to look at due process. And even though 7A says, you can't amend because you've already rested, and the prosecution's had 4 lawyers over there, and we read this to the jury, don't worry, prosecution. I'm going to help you out here because, hey, you're right. You didn't ask to amend count 4, and even though we went to indictment and got an amended indictment, aka superseding indictment, which replaces the indictment, that doesn't matter because you just specifically asked to amend count 4, which, like I said, you don't need it. In any other court in the land, you don't need to supersede on an indictment permission from the court. What the hell goes on in Idaho? I don't know. I don't have time to figure it out because the rules don't matter in Idaho anyway. So the court says, listen, the original indictment had what the prosecution wanted, and obviously they made a mistake, and, mistakes happen, right? I mean, and they've had 4 years to correct it. And, from the time that they filed this in February and we started the trial in May, who could be expected to possibly catch such a thing? And so, yes, count 4 was not amended. Therefore, the defense should have known. There's no prejudice. And that was the original count. And, oh, by the way, you heard evidence, Mr. Pryor, from the other case as it related to those dates. So you knew that those dates. So that evidence from the other case puts you on notice if that wasn't sufficient. So clear air, don't worry about it. And I have to balance the rights of fundamental due process
against the rights of the state to seek justice, and I find that the rights of the state to seek justice far outweigh any procedural due process rights that one may have to, have the right date on the indictment, on the correct indictment, if that is in fact the indictment, if at all. So don't worry about it. No big deal, no prejudice, no harm, no foul. Therefore, motion for judgment of acquittal as to count 4, along with all the other counts, no big deal. Hey, now the judges say, when we come back next week, when the defense begins their case in chief, we'll try to figure out how do we correct this. Do we just open the file? Do we just do a pen change? And you know what I say? Don't even worry about it. I think you just give them the first indictment, this amended indictment, maybe some jury instructions. Hell, let the jury figure it out, because the prosecutors can't do it. And listen, the prosecutors, this is the problem with the system. When you get judges who always want to help the prosecutors, when they screw it up, fix it for them, they never learn. If this was a defense attorney or a attorney in a civil case and you missed the wrong dates, you would be calling your malpractice carrier right away and saying, oops, we got a problem. But since they're the government, they have no one to report to, nothing bad is going to happen. They look silly for a few minutes, and then they get to say, there was even righteous indignation. Like, we told you we were right, Judge. I don't even know why it was an issue. And you wonder why, even though we were waiting through this, I was there live the entire time, talked about it for 2 hours. I said, if you follow the rules, they should grant the motion for judgment acquittal because no evidence was presented as it relates to the indictment that's filed and read to the jury. But I said, as a defense attorney and someone that's very cynical, that's gotten screwed many a time by the judge over the years, they're going to do legal gymnastics. And what did they do? They did legal gymnastics. Like I said, don't care. I just want the rules followed. I don't care about Chad Daybell. I don't care about his attorney, Mr. Pryor, but I want the rules to mean something. And if the rules don't mean something and the documents that get filed with the court don't mean anything, and you shouldn't be expected to rely upon that, then what the hell are we doing? What the hell are we doing, ladies and gentlemen? And listen, he's going to be found guilty. Let's just cut to the chase. He's going to get found guilty. But if we're not even going to follow the rules, ladies and gentlemen, scary day. I've always said, if we, the people, let the government railroad guilty people, guess what? They're going to do it to innocent people too. And the only people that stand between the government and the defendant, and maybe you someday or your family member, is a little defense attorney saying you can't do that. Constitution requires that I know what the freaking date is and what document is being filed and what I should be relied upon.
Top story today is top golfer Scotty Scheffler charged with assaulting a police officer. So let's just give you my biases right out of the picture, all right? I still follow golf. The reason I truly followed golf was because my son played junior golf. He played high school golf, and he played in college. My son was in the state 4A championship, I think 3 of his 4 years in high school, and he was a runner-up twice to a kid by the name of Wyndham Clark. Yeah, the kid that won the U.S. Open last year. So I follow golf because of that reason. My son played with a lot of these kids that are winning now on the PGA Tour. And there's another kid that my son played with at the Air Force Academy who's on the PGA Tour, a kid by the name of Kyle Westmoreland. And I say kids, they're young men. They're 29, 30 years old now, but they're still kids to me because, well, that's when I met them. Anyway, so Scotty Scheffler, all right? This guy is probably one of the most humble guys on the PGA Tour. His wife was pregnant when he was playing at the Masters tournament a couple of weeks ago. And he was asked, what would happen if your wife gave you the call that she was going into labor? And he said, I will leave immediately, even if I'm winning. Well, he wound up winning, and I think he's won like 6 of the last 7 tournaments, or 7 of all 7 tournaments that he's entered. That's how good this guy is. Most humble guy in the world, all right? Well, he got arrested early this morning and charged with felony assault on a peace officer and, let's throw in a little reckless driving, outside of the PGA Championship, which is in Louisville, Kentucky this week. Now, Mr. Scheffler was detained after he was seen driving on a median towards the entrance of the Valhalla Golf Club, the site of the event, and initially failing to heed an officer's order for him to stop. Now, this is all according to an ESPN reporter who witnessed the entire incident. So here we go. At the time of this all taking place, there apparently was a traffic outside the entrance, and it was being rerouted after a man had been hit and killed by a shuttle bus earlier in the day. This was causing all of the backup in traffic. So the players were trying to get to the club so they could begin their routine. So anyway, according to the police report, it alleges that about 6:16 a.m., Scheffler swerved into opposing traffic lanes to avoid the backed up traffic and gained access to the golf course, or attempted to do so. Apparently, there was an officer there. He was wearing his uniform. So the officer then stopped Scheffler and tried to give him some instructions. But apparently there was some confusion or misunderstanding, or he refused. That is yet to be determined. Anyway, Mr. Scheffler then drove off. The cop then somehow attached himself to the car, and after about 10 to 15 feet, the car stopped. That's when the police department says that the officer suffered pain and swelling and an abrasion to his left wrist and knee and was taken to a local area hospital. Now, according to the detective's notes, this officer, the uniform pants valued at approximately $80 were damaged beyond repair. And shortly before his scheduled tee time on Friday, Scheffler, in a statement, described the incident as a result of a big misunderstanding. He said, quote, "This morning I was proceeding as directed by police officers. It was a very chaotic situation, understandably so considering the tragic accident that had occurred earlier." Scheffler said in the post that there was a big misunderstanding of what I thought I was being asked to do. I never intended to disregard any of the instructions. I am hopeful to put this to the side and focus on golf today. Well, here's a picture. Mr. Scheffler's booked into evidence, and he's originally charged with second-degree assault on a peace officer, a felony, as well as third-degree misdemeanor criminal mischief, reckless driving, and disregarding a traffic signal from an officer directing traffic. Anyway, Scheffler was released at about 9 a.m. this morning, and he made his tee time for this morning as well. The attorney for Mr. Scheffler stated that he was driving to the golf course to start his pre-round preparations and proceeded as directed by another traffic officer. Now, due to the combination of events and traffic and a fatality, it was somewhat chaotic, according to Scheffler's attorney. And in the confusion, Scotty is alleged to have disregarded a traffic officer's signal, resulting in these charges. And he said that multiple eyewitnesses have confirmed that he, referring to Scheffler, did not do anything wrong, but was simply proceeded as directed. He stopped immediately upon being directed to and never at any point assaulted a police officer. Obviously, the assault is having the car allegedly drag him that the officer apparently got onto. Anyway, like I said, Scheffler made his 10:08 tee time that was departing from the 10th hole today, and he arrived at Valhalla about 9:10, only 10 minutes after being released, and had less than an hour to prepare. Like I said, this guy's got super focus. I bet he wins the tournament. Opened the door, at which point the officer pulled him out and pushed him up against the car and immediately placed him into handcuffs. Now, there are some memes going around on Twitter today that are actually quite funny, where they have the mugshot of Tiger Woods, John Daly, and now Mr. Scheffler saying, "Welcome to the club." Now, obviously, don't take a line of anybody getting prosecuted. I think this will probably be determined to be a misunderstanding, and Mr. Scheffler can certainly write this officer a check for his $80 work pants that was ruined, apparently, by being dragged. I'm sure he'll cover any medical bills as well. I don't see Mr. Scheffler ever getting a felony out of this, perhaps a traffic violation at most. I hope. And like I said, I'm biased on this one. Scheffler all the way. All right.